Good morning, everybody. If I could have our members log in, and I'm not going to put the same pressure on you that Chairman Hicks does in finance. He expects our fingers to be nimbler than they are. So I'm going to give you a minute for everybody to get in there. And then after I see people quit punching their devices, we'll take the roll. It's great to have an audience here today. You're at the most exciting committee in the General Assembly. I'm not sure that you knew what you were getting into today, but congratulations for being here. And for the dozens that are watching online, I know that last week you were looking for us, and it's kind of like when I was a kid and I was waiting for Gilligan's Island to come on. And there was a news special report, and I just missed it. And that was the way people were with Commerce last week. So, but we're going to make up for it today. We'll discuss that later, Chairman Powers. We have a full calendar, and now we'll give Chairman Clemens a moment to log in. And Madam Clerk, would you take the roll? All right. Would you take the roll and please count Speaker Marsh as being present?
Mr. Chair, you have 16 members present. You have a quorum.
All righty. Thank you very much. Before we get started today, have we got members with personal orders? I believe I see Chairman Moon over there. He was first up.
Thank you, Mr. Chairman. It is my great honor and pleasure to introduce to this committee a person who needs no introduction. He has served in the House, he has served in the Senate, and he has served as a U.S. Attorney, Mr. Douglas Overby, the Honorable Douglas Overby. Thank you, Mr. Chairman.
Welcome, sir. And Representative Lynn, I saw your hand up as well.
Thank you, Mr. Chairman. Representative Boyd and I would like to welcome everybody in the back of the room. It's the Mount Juliet Chamber of Commerce. It is their day on the Hill, and they're going to have a big time in your committee, Mr. Chairman. I know that.
All righty. Well, we're excited. Welcome, everyone. But I do have some bad news to report. I'm going to do the best I can today. But I've used my fourth guess in Wordle, and I still hadn't got the dang thing. So I don't know if I'm as sharp as I need to be for today's full calendar. As a matter of fact, we got some housekeeping to do before we get started. Apparently, traffic is a bear this morning, and we've got some presenters that need a little bit of grace with regards to what we're doing. So we're going to go through here, and House Bill 2159, item number 3, is without objection is going to be rolled 1 week. Without objection, rolled 1 week. Item 3, 2159. Item number 4, House Bill 470 is going to be rolled to the final calendar heel, the heel of the final calendar for House Bill 470 without objection. Roll to the heel. That is heel of the final calendar. House Bill 2453 is going to be rolled to the heel of today's calendar due to our sponsor having traffic issues. So, item 5. 2453 rolled to the heel of today's calendar without objection. Item number 6, House Bill 2454 by the same sponsor is also going to be rolled to the heel of today's calendar without objection. And then let's see, item number 2, House Bill 1705 is also going to be rolled to the heel of today's calendar. Again, we've got folks lost in traffic. So we're going to be bringing up House Bill 1705 at the heel of today's calendar without objection. So what in the world are we going to do? Well, we're actually going to go into some more rolling. House Bill 1709 has been requested to be rolled 1 week. House Bill 1709, item 12 is rolled 1 week without objection. All right. Now then, we're going to get to today's calendar and House Bill 2542. There's Representative Renaud. We got a motion and a second on it. Bill sponsor, could you please tell us what we're considering today?
Thank you, Mr. Chair. Committee, we have HB 2542. It's a straightforward cleanup bill to Tennessee's unemployment insurance statute that removes some outdated language and conflicting state language defining what qualifies as suitable work. Currently, Tennessee law contains state-level provisions that allow a claimant to refuse a job in the first 13 weeks if it does not meet certain wage thresholds tied to prior earnings. But the problem is our state only provides up to 12 weeks of benefit. So this simply deletes the outdated wage percentage formulas, and it does not remove any suitable work protection. So with that, I ask for your support.
Thank you, ma'am. Do we have any questions for our sponsor on House Bill 2542? Chairman Clemens, you appear to have something pressing.
Yeah, thank you, sponsor. Can you explain what the need for this was and where this is coming from? Is this it's coming from a constitutional officer?
It is coming from the Department of Labor and Workforce Development.
Okay, thank you.
And to add to that, Chairman Clemens, this is dealing with some cleanups from the indexing bill that we passed a few years ago. There's some coordination with some sections and dates and times in there that they cleaned up as a result of that they had discovered since then. That's my understanding.
Correct.
But I don't see any more hands up. I see Chairman Powers.
Question on the bill.
Chairman Powers is recognized and he has called the question. Therefore, we will vote. Unless I see some objection, I do not see 3 hands. We are going to vote. Everybody get ready to punch those buttons. Vote yes, no, present not voting. So everybody voted. Is there anyone that wishes to change their vote? I do not believe there is. Madam Clerk, would you read the results?
Mr. Chair, you have 22 ayes and no nays.
All righty. With that, House Bill 2542 passes on to calendar and rules. Thank you, sponsor.
Thank you, Chairman and Committee.
Going down our calendar, again, 1705 was rolled to the heel. 2159 was rolled a week. 470 was rolled to the heel of the final calendar. We're still looking for Representative Garrett, who is otherwise detained, but we've got Representative Alexander. Representative Alexander, it is so good to see you this morning.
Thank you.
We've got a motion and a second on House Bill 1958. You're in the proper posture. Would you like to bring us up to speed on what's been going on with 1958?
Yes. On 1958, we have, I think the amendment's already on it, sir.
Well,
I think that's right.
that is correct.
Okay. Thank you, Chairman. Thank you, committee. It's good to be in your presence today. I sure miss this not being on this committee. Always my fave. So glad to be with you all this morning. Current law requires businesses that pay employees based on commission earned in any given month to be paid by the 5th day of the following month. For example, commissions earned by an employee in January would have to be paid by February the 5th. As many of you know, the process of calculating an employee's pay when based on commission may take more than 5 days to verify and calculate. Many times an employer's books are not settled within 5 days of the close of the month, making it impossible to pay the correct amount owed. This bill would allow employers to pay piecework or commission-based employees up to the last day of the succeeding month rather than the 5th day of the succeeding month. This change would provide more flexibility and transparency to the process for employers and employees. Thank you, and I'm happy to answer any questions.
Thank you, Madam Sponsor. Anybody have any questions with regards to this one? Seems like a pretty straightforward deal. Seeing no questions, we're going to call for the vote. Madam Clerk, would you load the board? Let's. Madam Clerk.
Mr. Chair, you have 22 ayes and no nays.
That sounds like a win to me. Representative Alexander, you are off to calendar and rules with House
Okay.
Bill 1958.
Thank you, Chairman. Thank you, committee.
But hey, don't go anywhere. Stay right there.
Okay. I just didn't want to mess you up.
House Bill
so-
1034. We've got a motion and a second on House Bill 1034. I believe we have some amendment work to take care of on it.
That is correct.
Would you like to get those amendments in place before we discuss the whole kit and caboodle?
I
Or do
would,
you,
I would, sir.
all right.
And it would be 014277, is that correct?
That is one of the two.
Okay. Is there another one?
Yes, ma'am.
Okay, I've got a 012379.
Oh, I like it when we're in sync. That's awesome.
Okay, good.
All right,
Okay.
let's hear do I have a motion on 012379? I've got a motion and a second. All those in favor of putting amendment number 1? We did. Let's reconsider our actions and put it in reverse, folks. We considered amendment 1 last week because remember, we
Right.
had this one or 2 weeks ago and put it on then. Let's go to amendment 2, which is House Coding 014277. Do I have a motion? The second? All right, we're in proper posture. All those in favor of attaching amendment number 2, please signify by saying aye. Any opposed? No. You're properly amended. Now then, share with us what we're doing here on House Bill 1034.
Okay. This is the non-compete bill, and if you remember, last year I brought it before you all, and we decided that we needed to get some parties together to really look at this bill and make sure that we were doing it the way that we wanted it to go. So we had Chamber of Commerce, we had the music industry, we had NFIB, we had Office of the Courts, we had everybody involved taking a look at this bill. How can we best construct it to meet the needs of our citizens in the state? All this bill does is it creates a clear and predictable rules for non-compete duration. The bill establishes rebuttable presumptions for how long a restrictive covenant is considered reasonable, giving courts and businesses clear guardrails instead of a case-by-case uncertainty. It sets up reasonable time thresholds based on the relationship, up to 2 years for employee non-competes, up to 3 years for distributors, franchise dealers, and licensees, and up to 5 years for payment period for covenants tied to the sale of the business. The bill prohibits non-compete agreements for employees earning under $70,000 annually, ensuring non-competes are used only where they are most appropriate and defensible. Employers may still enforce confidentiality agreements, consumer non-solicitation clauses, and employee non-solicitation agreements. It allows the courts to modify, not automatically void agreements. Courts retain authority to alter a covenant to make it reasonable rather than throwing it out entirely. And that's what this bill does. And we have worked on, you had some questions. We went back to the drawing board for 2 weeks. We've worked on those. That's why you have the new amendment.
All righty. Thank you, ma'am. Do we have any questions for our sponsor? Chairman Powers.
Thank you, Mr. Chairman. I do have one. Who would enforce the non-compete clauses if someone breaks one of those? I've run into that before. I don't even know who the department is that would enforce that.
Enforce a non-compete.
Sponsor?
Yeah.
I'm sorry, Chairman, apologize. I'm assuming that would be the courts.
Well, pardon me, May I know that we've got a brilliant legal mind here, but I've been sitting around listening for a while. But again, I was pre-med for a semester, not pre-law, but it'd be my understanding it'd be spelled out in the employment agreement of the remedies that if somebody violated the non-compete. If one of our squires would like to, they're nodding in agreement. So that would be where the enforcement would come up from that.
Okay, all right. Thank you. Thank you, sponsor.
Any other questions?
Thank you, Chairman.
All right, I don't see any. Madam Clerk, would you load the board and let us take a vote on this? And sponsor, I'd like to say thank you for your willingness to take input and address these issues.
Thank you, Chairman, for giving me the opportunity to do so.
All right. Anybody want to change their vote? I was wondering if he could feel my icy glare on the back of it. All right, Madam Clerk, read the board.
Mr. Chair, you have 21 ayes and 1 nay.
All righty, motion carries, and let's see, that one is going to onward to health. No, that's not on to health. Yeah, it is on to health. Oh, it's double referred. Wow. You're off to health, Representative.
Awesome. All right. Thank you very much. Appreciate it.
All right, next on our calendar today is House Bill 469 by Representative Reeves. We're going to give Representative Garrett a little bit more time to settle down there. I saw him on a dead sprint into the room, so we're going to let him relax and enjoy the environment for a little bit. So you hang out there, my friend. We've got a motion and a second on House Bill 469. We also have some amendments along the way.
Thank you, Mr. Chair. We do, and if you want to take those up first, I'd be happy to do that or present the bill, whichever you'd like.
All right, so I think what we're going to do is let's present the bill and then we'll talk about the amendments following.
Yes, sir.
And some of those amendments were they already? No, they have not been taken up. So go ahead.
Thank you, sir. As amended currently, this bill is what I think is a narrow, limited change to Tennessee's existing residential landlord-tenant law, and it provides that a landlord may not prohibit lawful possession, carrying, transportation, or storage of a firearm inside of a tenant's leased residential premises. And it also allows possession in the tenant's vehicle, which is something this body did several years ago, and necessary entry and exit between the vehicle and the dwelling. The bill only applies to residential leases. It is prospective beginning January 1st of 2027, and it contains explicit exclusions for things like hospitals and nursing homes, assisted care facilities, certain independent living facilities, DCS and mental health facilities, state agency premises, and school property. At its core, this recognizes that a leased dwelling is somebody's home, and a renter should not have fewer rights of lawful self-defense inside their home than somebody who owns that premises.
Thank you, sir. And did you have folks here to testify, or are they just here?
I do believe I have somebody here to testify. Ms. Valerie? Yeah. Would you entertain going out of session to hear from her?
Yes, sir, we certainly will. Hi there, if you'd come down and have a seat at the table, we'll control your microphone. And if you would, as soon as I bang on this gavel, if you'd give us your name and we'd ask for you to limit your comments to 3 minutes, and then we'll see if the members have any questions for you. So with that, members, we're going to go out of session and hear from our guest.
Hi, I'm Valerie Williams. I live in Brentwood, Tennessee. And I am a grandmother who watches my grandkids a lot, one of my biggest joys. And the most valuable part of my life at this point is my grandkids. So when I'm watching them, I'm often walking in parks and such. And I don't live in an apartment right now, but I just imagine myself living in an apartment, which could be in my future, and not being able to have the guns that I grew up with. I am a law-abiding citizen. I, got a carry permit. I follow all the rules. And for this to be taken away from me just because I'm in an apartment would really worry me, because when I'm out, I have a 10-month-old that we walk around East Nashville. We really enjoy all the parks. And when we're out in those areas, sometimes it's very remote. There's no people around, no police around. And I think, I'm the only person between any harm coming to him and not. And there's all these headlines like with Laken Riley. And I just think, what would I do to protect him? I can't overpower any person that would do harm to us. So to be able to have that ability, I would need to have the ability to have those guns in my home if I felt like I needed that. And if I lived in an apartment, there's a lot of risk there too that I would like to be able to protect myself if I needed to. So that's why I feel so passionately about this bill.
Thank you, ma'am, for coming and sharing those opinions with us today and those thoughts. Do we have any questions for our guests? Anybody from the committee? We don't have any. So thank you again for coming today and sharing your views on the subject. And with that, we're going to go back in session and talk with our committee some more. Committee members, we've got a variety of amendments, but I think we've narrowed it down to where we've got 2 amendments that we'd like to present for your consideration today. And the sponsor has been, he's very passionate about his position on this and is a skilled arguer, I might say. He's passionate about his subject matter, but we have, Chairman Grills has an amendment to consider for the committee that addresses some concerns that we had brought to the sponsor previously. And do I hear a motion on recognizing, or do I hear a motion on hearing Representative Grills on amendment number 014595? Representative Grills, you're recognized. You're in proper posture. I've got a motion and second on the floor.
Thank you, Mr. Chairman. I would also add that he's persistent too. I just move for adoption. Pretty much what this amendment does, it codifies what he just explained a few minutes ago. It does remove the no longer mentions guest, and it allows the landlord to require that a resident or tenant transport the firearm between their vehicle and their tenant's residence.
All righty. You've heard the amendment, and we've had quite a few conversations about that. So if you would, we're already in proper posture. Do I have any questions for the amendment presenter? Seeing none. All those in favor of applying 014595 to House Bill 469, please signify by saying aye. Aye. Any opposed? No. The ayes have it. The bill is amended with that one. And then I have an amendment to consider, and so we'll pass the gavel down to Vice Chairman Brickens. All right. Let's see. That amendment would be, which we have a motion in a second. The amendment 013431. Motion.
All right, we have a amendment in proper posture. Tell us about your amendment.
Sure. Let me explain what my thoughts are in this. And what I'm doing is adding an exclusion for independent living senior facilities. And the reason behind it is I don't know how many here have experienced elderly parents, but I know that the older you get, and I am on a steep, rapid descent into that area myself, is that there are events that can occur that are temporary events in a senior's life that can render their judgment or impact their judgment, things such as dehydration, things such as getting their prescriptions either mixed up or maybe an overtaking or an undertaking of a certain prescription. I know that in some cases, a UTI can throw people off. And so my thoughts is that because we've got a population control of a 55 and above senior independent living facility, to where the instances of this occurring would be greater than the normal population. And so what I would hate to see is that someone on their worst day do something to someone else that is within the same premises that they are. And so that would be why I would be offering this amendment. And I've come full circle on this because y'all all know that in the past, I am a no shoes, no shirt, no service guy. That a property owned by somebody else is theirs to make the rules on. But our bill sponsor has so eloquently demonstrated that the Landlord-Tenant Act that's already in code removes some of those rights already from the landlord. And so this is going to be one other thing. But I told that the sponsor that I would offer this amendment separate from the one that Chairman Grills did earlier, so that he'd have a chance to rebut those, and then we'd those concerns, and we could offer it to the committee for a vote. So, Mr. Sponsor, you're recognized.
Thank you, Mr. Chair. We did talk about this, and I appreciate your working with me on this bill and on the language and agreeing to talk about this in committee. My position is that the language currently in the bill already addresses the concern that the amendment is trying to solve. What it does currently with Chairman Grill's amendment is it excludes an independent living facility with respect to any residence or dwelling unit that opens directly into an interior corridor or common area that serves as a means of ingress or egress to a home or facility listed in the section above, which is nursing homes, homes for the aged, adult care homes, assisted care, living facilities. And this amendment would instead exclude all independent living facilities, including ordinary 55-plus residential communities that function like standard apartments or condominiums. And this is why that matters. Facilities connected physically to nursing homes or assisted care have shared medical services. They've got shared staff. They may have shared corridors. And they've got a higher concentration of vulnerable residents, but ordinary living communities are simply housing. And that's why I would encourage us not to put this further restriction on, but that is at the will of the committee. And I'd love to have additional conversation about that.
Members, you've heard the explanation. Does anybody have questions of the sponsor or to the chairman on the amendment? Seeing none, I think, are we ready to vote on the amendment? All right, seeing no objections, all in favor of putting this amendment on the bill, say aye. Aye. All opposed, say nay. Nay. I'm going to declare a nay.
Thank you, Mr. Assistant Chairman. My eyes got to be a little louder next time. Nose were all fired up this morning. They were fired up. All righty. Well, I think we're in proper posture. Do we have any more questions for the bill sponsor? Chairman Clemens, you're recognized.
Thank you, Mr. Chairman. Again, as I said in the last hearing on this topic, I think there's a couple inherent flaws with this. I think we are overstepping property owners' rights when it comes to this, prioritizing certain parts of the Constitution over others, which is always a bad idea. There are landlord requirements currently in the Landlord-Tenant Act, but those are things to protect the tenant and the integrity of the property, warranty of habitability, those types of things to make sure the proper living conditions, that the water's running, that there's no mold, mildew. Those are the type of limitations or requirements on landlords currently, which certainly makes sense and in the public interest, which is what we always seek to serve. The inherent problem here is over the past few years, we've eliminated any training to have a firearm. Handguns, you can do anything. So anyone can go out and get a handgun with no training, no proper use of it. Maybe not even any experience firing the handgun. And here we are setting up a situation where you have shared walls. You have certain families of children, mothers, parents doing everything they can to protect these children. And you're sharing a wall with somebody who may have a gun, doesn't even know how to use it, creating a threat of harm to that family that's just trying to get by, live their life in peace and in a safe manner. There's nothing in the law currently that says landlords can't allow firearms. So anybody out there who is leasing can go find an apartment with a landlord that has no problem with this. And you can do so knowingly. And that way, everybody in that facility is on the same page. You know that that's a firearm-friendly housing development or rental property. Landlords currently are required to maintain a safe premises. They have to have proper lighting. They have to have proper passageways that are well lit, that don't create a threat of harm or any other sort of danger to their tenants. That is the law. And here you're putting more potential for liability on the back of a landlord who may be sued for lack of knowledge that somebody has a propensity to commit crimes, who's now carrying a firearm that they can't prohibit on their property. Again, their property rights that we're stepping on. So there's a lot of issues with this. Look, I'm a firearm owner. I respect the Second Amendment, but here we're placing certain parts of the Constitution and amendments on top of others. And prioritizing them in this way is always a dangerous matter. And again, we're trampling on the rights of property owners here. And there's nothing saying you can't have a firearm in a leased premises if a landlord allows it, which is currently allowed. So we always talk about protecting the market in here and giving people the right to do what they want without stepping on property owners' rights. So let's respect the market, let the market play out. And people can live where they choose, and landlords can do what they want with their personal property. Thank you, Mr. Chairman. I appreciate it.
Thank you, sir. Do we have any other? Let me go back for a rebuttal from the sponsor, and then I saw Leader Camper's hand up. Go ahead, sponsor.
Thank you, Mr. Chair. And I'll keep it short. There was a lot in that argument, and I'll just address kind of some of those for the benefit of the full committee. Property rights, I respect landlord property rights. I absolutely do. But the General Assembly, as I said in subcommittee, has long regulated certain aspects of residential lease provisions as a matter of public policy, including habitability, which protects the tenant. We've got security deposits that are regulated. We've got eviction procedures. Landlords can't automatically just enter a premises without proper notice. Unless there's an emergency. We've got fair housing protections. There's all kinds of things, and this fits squarely within that framework. Leader Clements mentioned liability. Well, this bill expressly states that civil liability does not arise solely from compliance. In E of both Section 1 and 2, it says civil liability does not arise for a landlord solely from complying with this section. And I have worked with some landlord organizations that are satisfied with that language. And then last, the comment about a residential tenant can simply go somewhere else. Two comments on that. The first is residential leases are not usually negotiated line by line like commercial leases are. That's the first thing. The second thing is situations may change during a period of tenancy. And because of that, I think this bill needs to be carefully considered in advance. And I appreciate your time.
Thank you, sir. Leader Camper, you're recognized.
Thank you, Mr. Chairman. Thank you, sponsor, for your bill. I understand what you're trying, where you're trying to go with this bill and the concern like the grandmother have. And we talked about this in subcommittee where I had concern about the individual property owner like myself who rents property and in my leases and other people's, when they're drafting their lease, could explicitly say no firearms on the property. And what I'm seeing in this bill is that my property rights will be violated if I even try to put such language in a lease, where if I'm let's say my mother who has a basement that wants to rent to a college student or whoever she wants to rent the basement to might want to say no firearms. And if they have firearms, then that would be a violation of that lease agreement. And this bill would say she couldn't do that. And I believe probably could subsequently be, a lawsuit could be, filed against her for telling a tenant they have broken the lease. So am I true in my assumption of what could happen to a person who decides to have that in their lease and somebody break the lease and then they say you have to move, and then now they could be sued because this bill said that they can have this weapon in my property?
Mr. Sponsor.
Well, and I appreciate that question. And I'll give you the same answer I gave you in subcommittee, which is that as a landlord, even an individual landlord renting out a basement apartment, that you are still subject to limitations on what you can do as a landlord, including providing all necessary utilities. If you don't do that, your property rights aren't violated. That's simply a requirement under state law to do that for the protection of the tenant. Same thing about entry notices. You've got to give proper notice in order to enter. You've got to make sure it's habitable. And that is for the protection of the tenant. And that's why we've taken that step already in state law for those various things. I think this fits within that framework. And most landlords, I'll just point out, whether they're an individual or a large corporate landlord, they're not taking on an affirmative duty of protection for that tenant. And that's not something we require. That's not something I think we should require. But because they are not, I think that tenants should have the ability to protect themselves.
Leader, you good, or you need to follow up?
Thank you, Mr. Chairman.
All right.
Thank you. I understand your position. I understand what you're saying, but if I tell a tenant that no pets allowed, no smoking in my property, no weapons in my property, and they sign that agreement with me as the landlord, I think they should be bound to that because they went into a contractual agreement with me to not do these things. And if you do, there are terms within the contract that say you would have to move within 30 days, or you would have to, if let's say it was smoking, you'd have to, clean it up and be whatever the terms are in the contract. I feel as a property owner in this contractual agreement, they should abide by it and because they signed the agreement. Now, if their circumstance change, which I think I heard you say, then they can come to the landlord and say, hey, look, I'm being stalked. Is there a way to waive that portion? And then now I'm more informed and I can say yes or no because we've signed a contractual agreement. But what it appears to me in this, it doesn't matter what I say. That I would be in violation if I tell them they violated the contract that they signed with me. And so I just have a problem with that. But I understand what you're trying to get at, and people have no problem with that. But I think if a person goes enter into a contract with someone, they should be bound to that contract.
All righty, we're going to move on because I think
I got you, Mr.
I didn't hear a question there, and I'm hearing
I did.
the sponsor repeat his position. I'm hearing people state their positions. I'm not hearing questions, but Chairman Powers, do you have a question?
Thank you, Mr. Chairman. I just wanted to point out a couple of Supreme Court rulings. Heller, 2008, it recognized an individual's right to possess firearms for lawful purpose, especially self-defense at home. It doesn't break that down. What home could be, I guess that could be anywhere, like under a bridge where I'll be living at one point probably in my life. Okay, and McDonald, 2010, incorporated the Second Amendment against state and local laws. So it looks like the Second Amendment overrules a lot of things that we've been arguing about today, that we have that right. It also mentions that the right's not unlimited. It allows restrictions on felons, mentally ill, and certain sensitive locations like school and government buildings. But it does give you the right to have a firearm at your home. That's basically what the ruling is. Would you like to comment on that? I mean, is that what you consider too?
Well, I think I'm going to decide whether or not the sponsor answers that,
I'm sorry.
Mr. Chairman, and I think I understand that the sponsor probably agrees with that. So if we got other questions, I saw Representative Grills hand up.
Thank you, Mr. Chairman. I'm just going to call question on the bill.
All right, he was recognized. And the question, is there any objections to calling the question on this one? I do not see any objections. So, Madam Clerk, would you open the board for voting? Anybody want to change everybody voted? Anybody need to change their vote? I'm not sensing that to be the case. Madam Clerk, would you read the results, please?
Mr. Chair, you have 15 ayes, 3 noes, and 2 present not voting.
All righty. Thank you, ma'am.
Thank you, Chair and
Representative, your
committee.
bill is off to calendar and rules.
Thank you, sir.
We're going to go back and catch Representative Garrett down there, who's fresh off the road wars on the interstate. Representative Garrett, how about House Bill 2543? Can you share a little bit of information about that? Once we get a motion in a second. 2453, did I say, was I? Oh, 2453, I'm sorry, sometimes I get.
2453.
Yes, a lot of numbers running around this head today. You have a motion and a second. You're in proper posture, sir. If you could present 2453 to us today.
Thank you, Mr. Chairman and committee. Appreciate the time to give me a little time to get off the interstate and get here. Apologies for being a little bit late, but thank you, Mr. Chairman. This piece of legislation was brought to me by the Attorney General's office. It deals with the Tennessee Consumer Protection Act. And as you all know, that's a broad form of laws that protect consumers as they interact with commerce. When they buy goods, et cetera, and they get advertised and whatnot, can't be deceptive in what you do to advertise your product. Several things this does, and one of the things that I didn't mention in sub, but it also touches the Tennessee Information Protection Act, which this committee remembers that piece of legislation that took me a couple of years to pass. What this piece of legislation does is basically update a couple of provisions that have been traveling through the system, may have had some issues in the federal court system. But with that particular act, the TIPA, biometric data, I think, is going to be something that's going to be ever changing of how we use that. So we're updating that portion of the Tennessee Information Protection Act to make sure we narrow the scope and capture what biometric data is, which is your retina, facial recognition, et cetera, for everything we do on our phones these days, making sure we capture and protect that data for consumers. It also streamlines certain lawsuits that the Attorney General is in with the assurances of voluntary compliance. I mean, you don't have to actually file something with the court. You can do that outside the court. It also updates and clarifies what is and is not an unfair or deceptive act. One of the most important pieces of this legislation under Section 3 is the limiting the discovery that plaintiffs have. And what's been happening, Mr. Chairman and committee, is that if TDEC is sued for a particular provision or whatnot, then all of a sudden they can put discovery on the Department of Safety, which has absolutely nothing to do with the merits of the case against TDEC. So we're narrowing the discovery so they don't actually have discovery rights for the entire state instead of whatever agency or whatever part of the state they're suing. The discovery has to be limited to that. That can obviously bog down lawyers, bog down time, be cost effective, and slow down the litigation. So we're narrowing the discovery to make sure the discovery applies to the actual discovery they're trying to obtain and not slow down the litigation. Also, we're doing several different things in Section 5. This General Assembly has already prevented class actions. We're narrowing this exception because there's a case out of Utah that says in a state action, we've prevented the ability to have class actions in certain scenarios. So we're clarifying that to make sure that that can't be preempted. In Section 6, we're also making sure that ticket prices are clearly disclosed. Obviously, there's a lot of litigation potentially on the Tennessee Consumer Protection Act as it relates to the disclosure of ticket prices and what those cost. We're clarifying and strengthening that particular provision to make sure people don't get hoodwinked when they buy tickets online, et cetera. So with that, Mr. Chairman, that's a brief summary of this piece of legislation as fast as I can honestly do it. But we welcome to answer any questions the committee has, any details further.
Thank you, Representative Garrett. We do appreciate brevity around here. Does anybody, speaking of which, now, does anybody have any questions, any long-winded questions for our sponsor? Chairman Clemens, you're recognized.
So explain to me the narrowing of discovery portion. That is
Sponsor.
Well, just go ahead.
Sure. Thank you for that. And I appreciate the opportunity to do that. If you have a particular action that involves the Tennessee Department of Environment, right, and it's exclusively within their jurisdictions, exclusively with that particular piece of whatever the plaintiffs are suing, what we're finding is that the plaintiffs are taking the position that since they're suing the state, they have discovery over every agency, every part of the state, and they're sending discovery requests, interrogatories, or requests to produce documents for something that is wholly independent of whatever they're suing the Department of Environment and Conservation for. So that's why I used that example. If this Department of Safety or you pick the department, TDOT or whatever the case may be, has absolutely nothing to do with the merits of their case, they can actually send discovery and then we would have to respond. And basically the response is, we don't have any responsive documents. We don't have any responsive questions or answers to your particular discovery because it's not applicable to your lawsuit. And if they agree, then they got to go in front of the judge and they have a discovery dispute. So it's been used to delay litigation on something that typically doesn't reveal any discoverable material because it's irrelevant to the lawsuit. So we're trying to narrow that discovery piece to say, if you're suing TDEC, it's got to be related to what TDEC did or didn't do as it relates to your lawsuit. You don't have the automatic right to put the discovery on the governor's office or the General Assembly when we had nothing to do with that particular piece of litigation. Does that make sense?
Chairman Clemens, I can tell by your furrowed brow that you've got a follow-up.
I came by that furrowed brow, honestly, from my father. I apologize. That makes sense what you're saying. The problem is that's the point of discovery, is to figure out who all was involved with certain decisions and actions. And so, if a department does something, then as an attorney, you're not looking to waste a lot of money with frivolous discovery. I mean, that's a factor in consideration. Generally, if you're the plaintiff, you're not looking to delay a lawsuit. Generally, the defendant's the one seeking to delay the lawsuit. Third, the problem is with that is, how are you to know? I mean, if you're seeking relevant and documentation allowed under the rules of civil procedure, then if something is not relevant or outside the scope or something like that, or falls in any of the categories of objections set forth in the rules, the Attorney General can object and not do that. But if you're an attorney trying to carry out your discovery process, then you need to know who all was involved. TDEC may have been acting at the behest of leadership of the General Assembly. The Department of Safety may have been acting at the behest of the governor's office, which is generally the case. So why are we seeking to preclude the opportunity to actually conduct discovery when the Attorney General has the rights under the rules to object under multiple grounds and just say there's nothing, or say there's nothing there?
Mr. Sponsor.
Thank you, Mr. Chairman. That's a good question, Chairman Clemens. And I would say that in any complaint, which therefore requires an answer, you've got to determine and establish, at least in the face of your complaint, a nexus to what you're trying to see. You can't use discovery as a fishing expedition. You can't use discovery if you don't allege something in the crux of your complaint that you would automatically get to blanket the state and blanket the state agencies with discovery that's not going to be included or has some sort of nexus to your case. So if your complaint alleges some sort of coordination between, my examples, TDEC and TDOT, or TDEC and the legislature, or TDEC and the governor, your complaint alleges that, you certainly have the right to make that case and pursue discovery on that basis. But if your complaint, which is the basis of your issue, the basis of any plaintiff's case is their complaint, mentions nothing, alleges nothing about any interdepartment agencies with the state, you don't automatically should have a right to discovery to do a fishing expedition, which does nothing but slow down the case, stymie discovery, and does nothing for what you're trying to pursue your relief under the complaint. So if you have that, a plaintiff certainly has the right to make that case, but they've got to make that case in the complaint. What is happening is, in these complaints, in these lawsuits, they're making no connection whatsoever. They don't even connect that the agencies acted in consort, had anything to do with each other, but yet they believe, by virtue of suing a subdivision of the state, that they have automatic discovery rights to the entire state, to every single agency, to Medicare, to not Medicare, pretend care, for anything that we touch in any lawsuit that has nothing to do with a lawsuit. Some of these plaintiffs believe they have blanket discovery across the state, and they just do not do that. That's what this provision is clarifying, that if you believe there is some concert, you must allege that in the complaint to make sure your discovery is relevant. You don't get the ability to just blanket the state with discovery requests to stymie the litigation.
Hold on just a second, Representative Clemens. I'll come back to you, give you a minute here. We hadn't heard from Representative Hemmer today, and he was here on time today, and we just want to make sure that he gets to ask his question, but I will come back to you, for your follow-up on that, but I think we've beaten that drum a little bit here. So Representative Hemmer, you're recognized.
Thank you, Mr. Chairman. Forgive me, sponsor, to step out for a second, but curious the nexus of this bill. Did it come from the Attorney General's office?
Yes.
Okay.
Excuse me, Mr. Chairman.
That's all right. Representative Hemmer.
And then appreciate the language around the strengthening the Tennessee ticket transparency law. There was a certain representative, very tall, dashingly handsome, not named Kurt Haston, who did this law 2 years ago.
I don't recall doing that.
There was a lone no vote in the Commerce Committee 2 years ago by a certain sponsor, and I was just curious, what's the change of heart in strengthening this law now?
Mr. Sponsor.
What's the argument in strengthening this particular provision to the handsome fellow you refer to then? Is that making sure I'm with you here? You threw me with a handsome fellow that did the bill.
Representative?
No, just curious that there was a no vote by the sponsor on the Tennessee ticket transparency bill 2 years ago, and I was just curious why you're now supporting it.
On the bill 2 years ago?
A bill I sponsored 2 years ago.
I support making sure, excuse me, Mr.
Hold
Chairman.
on, Mr. Sponsor. I think point has been made here. We're not going to go tit for tat about former votes. If we do, I'm going to get my hackles up about a vote about 20 minutes ago. So we're taking selective. We're going to have amnesia about former votes. We're talking about the vote we're about to take.
Fair enough.
Point was made, Representative Hemmer. And I think we've probably given Representative Clemens time to contemplate his final question on this bill today. So Chairman Clemens.
Thank you, Mr. Chairman, and I'll be brief. I appreciate with the spirit of the legislation and certainly parts of this legislation, but the response to the discovery question is concerning because there certainly should never be a fishing expedition, and most good attorneys are not going to do that, and most plaintiff attorneys are never going to purposely delay litigation because it just costs them more money and their client. The fact about not knowing or not putting something in the initial complaint ignores the very purpose for joinder, amending complaints, and the like. So you certainly learn things during discovery process that leads you to ask and request other information in the discovery process. And if we're precluding that in any way, that is concerning, and it really concerns me that the Attorney General, whose budget we've tripled or quadrupled in recent years, is under the impression that he doesn't have the resources or the time to respond to discovery requests. That is that's concerning on multiple levels. But again, I agree with most of the legislation, but to the extent we're trying to limit discovery and somehow protect individuals or hide facts in some way through the codification of this bill, I take issue with that. So thank you, Mr. Chairman.
All righty, thank you. Do we have any? Oh, we're good here. Leader Camper, brevity is warranted today. We still have so many exciting topics to cover.
I thought you would have told handsome, dashingly man he was referring to.
I was hopeful.
Representative, on section 5.
Yeah.
Could you clarify the change there? It said may sue. You changing language from may sue for and recovery to substituting may individually sue. Is this getting rid of class action? What are we doing with that?
Mr. Sponsor.
Thank you, Mr. Chairman. This General Assembly has already narrowed the ability to sue for a class action. There's just been some federal case law that has misapplied what we
Okay.
believe, and we're clarifying that to be consistent. So we've already eliminated that ability to do a
do
class
that.
action. We're just clarifying, given a case out of Utah that was conflicting, we're clarifying that to make sure we're consistent.
Thank you, Mr. Chairman.
Sure thing, Leader. Any further questions for our sponsor? Remember, we've got him for a second half too coming up, and it's even more riveting topic than this. I see no more questions. So with that, we're going to call for a vote, and maybe a vote too. Madam Clerk, please load the board. Please call the vote. Madam Clerk.
Mr. Chair, you have 17 ayes and 4 noes.
Thank you. And with that, House Bill 2453 is off to calendar and rules. Next up, we have House Bill 2454 by the same sponsor, Representative Garrett, this is this year's edition of trust updates. And again, my friend, you'll be rewarded someday, maybe for posterity, with brevity on this matter. Thank you.
I'll be as quick as I can, Mr. Chairman. Thank you. We're in the proper posture, right? We're ready to roll.
No, we're not, sir.
There we go.
Now we are.
Thank you for that, Mr. Chairman. This is my 8th time to present on behalf of the Bankers Association our trust legislation, and I'm proud and honored to do that. My most favorite statistic as it relates to this, I think the first time that I've done this piece of legislation, we were about $8 billion under trust here, dollars wise, and now we've gone to $300 billion here in the state that has trust assets under management here in Tennessee. And one of the reasons why is this good committee's work, along with the Bankers Association, their committees that have produced this legislation to make sure we tend to get people's dollars here and not necessarily have the people here. So I'll go as brief as I can, Mr. Chairman, but here are what the updates are to this piece of legislation. We've been having some issues with some probative wills that come from, they're called foreign wills. They're not foreign as into the country. They're foreign as if it's from Kentucky or Alabama. Those are referred to as foreign wills. They may have different requirements to their wills. There's an actual statutory requirement of how you execute a will. We want to make sure we recognize another state's will if it's executed on the terms of that state. They may be inconsistent with the rules about making a will here in the Tennessee. It's an otherwise valid will in another state. We're going to recognize that will here. Also, we update what charitable organizations naming beneficiaries can receive required accounting information to participate in non-judicial settlements. If there's a settlement for a trust to be distributed, a non-judicial settlement means just that. We don't have to go to court to get that approved. It's cheaper, it's more effective. All the parties are agreed to it, so we can do a non-judicial settlement. We also make sure we protect beneficiaries that can't unilaterally appoint their buddies, so to speak, their comrades as a trust protector, because a trust protector has an ultimate role to make sure the beneficiaries and the trustees are protected. You can't protect someone that you know that can otherwise do something inconsistent with the trust terms. We're also raising in a trust, if it's valued at $100,000 or less, that trust can be automatically distributed out because it's not effective. We are actually raising that threshold to $250,000. It's been $100,000 for a number of years. The cost of inflation makes this make sense. So if you got a trust that's $250,000 or below, that can be automatically terminated and distributed out to the proper beneficiaries. We're also amending some things for expenses where we can automatically pay at the trustee's discretion, attorney's fees, CPAs, regular course of administration costs for the trust. And I will follow my chairman's lead and renew the motion. If there's any questions regarding any other provisions that I haven't mentioned, I'll be glad to address those. With that, I'll be glad to take any questions.
All righty. Thank you for that very detailed analysis and presentation. All in the
Gotta get it all in, Mr. Chairman.
in the briefest possible way. Do we have any questions with regards to this? I see people saying, please no. So, all right. With that, we're going to open the board for voting on this matter. Madam Clerk, thank you very much. All right. Anybody wanting to change their vote? I'm not seeing that. So let's call the vote, Madam Clerk.
Mr. Chair, you have 21 ayes and no nays.
All right. 21-0 sounds like a win to me. So you, sir, are off to calendar and rules.
Thank you, Mr. Chairman and committee.
All right, moving on down, we're going to pick up back on item number 10. Our very own Chairman Martin. Motion. We got a motion and a second. You're in proper posture, sir. Tell us what we're doing down, what's happening down in Gibson County.
That's right. Thank you, Mr. Chairman and committee. We have had a great hour of questioning. Hopefully this one will be the easiest one all day. So what we're doing is a local utility bill for Gibson Utilities. This bill will amend the current private act of Gibson Utility, so it does not prohibit a commissioner from serving more than 2 consecutive terms. And with that, I stand ready for question. There we go.
Any questions out there? I see none. Madam Clerk, would you open the board for voting? If anybody's going to change their vote, do it now. If not, Madam Clerk, let's call the results.
Mr. Chair, you have 20 ayes and no nays.
All righty, thank you, ma'am. Chairman Martin, you're off the calendar and rules. Speaker Marsh, House Bill 1800. We got a motion second, sir. You are in proper position. Please share what we're doing with House Bill 1800.
Thank you, Mr. Chairman. This bill is brought to us by the Tennessee Banking Association, and it addresses digital assets. This bill is about modernizing Tennessee's commercial laws to keep up with today's technology. This would enact UCC Article 12, which will give our courts, businesses, and banks clear rules for how digital assets can be owned, transferred, and used as collateral. More than 30 states have already adopted these updates, and Tennessee is falling behind. It's needed to provide clear legal rules for owning, transferring, and using digital assets that exist only electronically. This bill is 75 pages long, and like Representative Garrett's, I will shut up and ask any questions.
Bless your heart, you did it a lot sooner, Speaker Marsh. Deputy Speaker Zachary, you're recognized, sir.
Thank you, Mr. Chairman. Thank you, Speaker Marsh, for the bill. A couple of years ago, when this came before us, there was some concern, and we put a stop on this bill because there was some ambiguity around the language related to a central bank digital currency. We, as the General Assembly, over the last couple of years, have taken action related to a central bank digital currency, strictly prohibiting those. And I know the answer to this, but I just want to get on record, Speaker. This legislation in no way creates or allows for a central bank digital currency, correct?
Speaker Marsh.
Correct. Thanks for the question.
Thank you, Speaker. Thank you, Mr. Chairman.
All righty. I also saw Chairman Grills' hand up. Chairman Grills.
Thank you, Mr. Chairman. Move previous question.
All right. Any objections to the question? Seeing none, the question has been called. All those in favor of approving House Bill 1800, please signify by pressing the green button on the screen in front of you. Anyone want to change their vote? Do so now. If not, Madam Clerk, let's read the results.
Mr. Chair, you have 21 ayes and no nays.
All righty. Thank you, ma'am. Speaker Marsh, you are on to Judiciary. Good luck there. Chairman Boyd, House Bill 2108 is next up on our calendar. We've got a motion and a second. Sir, you're in proper posture, and I think we've got some amendments. Why don't you?
Thank you, Mr. Chairman. I do have a new amendment. I've got drafting code 014413.
Good to go. Do you want to put that on the bill?
Let's
or
go and put it on there, Mr. Chairman. I'll explain later.
All
if I
righty.
can.
Sound. Got a motion and a second. All those in favor of applying said amendment to said bill signify by saying aye. Aye. Any opposed? No. Bill's amended, sir.
Thank you, Mr. Chairman. Members, this is the legislation that I ran a couple of weeks ago in subcommittee, and we needed to put an amendment on there to address the concern that some of you guys had with regard to the discovery phase of the lawsuit if this came out. And so what we have done is we're requiring disclosure. So what this bill would do, it would protect the consumer when it comes to consumer litigation financing. And so it does a few things. It prohibits financiers from some of the countries that George W. Bush would refer to as the axis of evil. They cannot fund these. They cannot direct litigation strategy, settlement decisions, attorney selection, anything like that. The financiers are jointly and severally liable for court cases or sanctions, and they must share in the downside of the risk as well as the upside. It caps the annual fees at 10%, and it requires that they cannot receive more money from the settlement than the plaintiff does. And so, Mr. Chairman, that pretty much sums the bill up as amended. I think there are some people that would like to testify, but in the spirit of brevity, if we want to go ahead and vote on it and move it out, I'd be fine with that too.
Well, we do have some guests from some distance, and we're not going to do that to them if they've invested their hard-earned current non-central bank digital currency. then we're going to hear from them. So we're going to go out of session. We would ask that, and I'm sorry if I don't pronounce this right, Daiwei Chin Fiman. That's the best I can do with your name, sir, and I hope to hear it down here spoken properly. And then also Mr. Phil Goldberg also is coming. If you both come down, and you can if y'all don't share the same views, you can sit on each side. It's up to you. So we'll go at first with. Well, we've also got Brandon's. We've got 4 of them, excuse me. I only thought we had 2. Brandon Smith from the International Legal Finance Association and Charles Agee with West Fleet Advisors. And so if you would, we've got all 4 loaded up. If you'd limit your comments to 3 minutes apiece, we'll keep a clock on you here, and we will be less than ceremonial when you have exceeded that 3 minutes. But we would like for you to tell us your name, identify who you're with, and then share your thoughts on this matter. And with that, committee, we are now out of session. And sir, you're up first.
Great. Mr. Chairman, member of the committee, my name is Phil Goldberg. I'm an attorney at the law firm of Shook, Hardy & Bacon in our Washington, D.C. office. And I'm here today testifying on behalf of the Institute for Legal Reform of the United States Chamber of Commerce. We are testifying in support of this bill because the business community, both as plaintiffs and defendants, are seeing firsthand how litigation investing takes litigation out of the hands of the courts and the parties and gives it to outside investors. Nationally, these investors are determining which cases are brought, how long they are pursued, and when they are settled and for how much. All without transparency to the courts and to the parties, often including the plaintiffs whose cases they are investing in when they're investing in portfolios of firms, of an entire firm's cases. The purpose of this legislation is to make sure the courts can continue to work fairly. It does so by bringing the industry out of the shadows. And to be clear, this legislation is not about stopping litigation investing. Like the bill enacted in Georgia, it institutionalizes litigation investing and provides basic guardrails that are sorely lacking. Outside litigation investing is a new development of the past 20 years. Historically, it was not allowed because the civil justice was seen as a place to resolve disputes. But today is one of the most rapidly growing investment sectors. We have hedge funds, sovereign wealth funds, and foreign businesses buying into a lawsuit for a financial return. They have an estimated $16 to $20 billion invested in U.S. litigation, which is expected to double over the next few years. And so this whole industry has gone from 0 to 60. With no rules of the road to protect the integrity of the civil justice system. And let me tell you briefly what we have been seeing. In the mass tort space, where about 2/3 of the money is going to portfolio funding, they build litigations that are too big to fail. They advertise for plaintiffs, pay scientists, pay lawyers. Often up to half of the plaintiffs just click through. They can't even show they have the injury or use the product at issue. And their claims are not vetted. They interfere with the parties' decisions in their own lawsuits. Some agreements give funders control over the litigation. In Cisco's antitrust case, the funder vetoed the settlement, and then when Cisco wanted out, the funder took over as the plaintiff in the case. The court said the agreement allowed it, but took the lawyers to task for being beholden to the funders and not Cisco, their client. And we're seeing foreign entities funding lawsuits for strategic goals. The GAO report said that sovereign wealth funds, and we've seen it from the United Arab Emirates, are involved. Former Attorney General Michael Mukasey talked about a foreign chip manufacturer that funded litigation against Intel to get Intel's IP. There's a Chinese firm that was financing IP cases in the United States, with the former acting director of the USPTO described this development as our worst fears confirmed. And the chief of the Foreign Agents Registration Act said that foreigners are using litigation investing to gain access to sensitive U.S. information and sow discord in American industry. Mr. Chairman and members of the committee, this bill addresses these specific issues. It requires disclosures when investors are in a case. It bars funder control. It bans foreign adversary funding, and it makes sure that funders don't get more than the plaintiff. This language represents a negotiated compromise between the Tennessee Chamber and the Tennessee trial lawyers.
Thank you, Mr. Goldberg. We appreciate you sharing your thoughts. Next up, over on this side, if you could identify yourself with your name and who you represent, and you, sir, also have 3 minutes.
Yes, thank you, Mr. Chair. Daiwei Chin Fiman is the pronunciation according to me, not my mother. From New York, on behalf of the International Legal Finance Association, or ILFA, we are the trade group for the commercial litigation funding industry. I'm here to oppose this bill. I'm very grateful for you hearing me out. We've just heard the parade of horribles about litigation funding. I want to tell you about what we are, but what we aren't. We are funding high-value business-to-business disputes, as well as enabling lawyers to have robust contingency practices to hold woke corporations accountable. You just heard a number of examples that I've heard for the past 8 years doing this, cherry-picked examples here and there, all of which have a story that has nothing to do with this. We are here to support reasonable regulation, which is what we have done with him, his organization, the U.S. Chamber of Commerce, in Kansas. In response to these same concerns, we negotiated a compromise on disclosure, on foreign funding. The chamber is unwilling to negotiate with us here. They claim to have a negotiated deal with the trial lawyers, not the actual litigation funders. They haven't heard us out. We've been telling them this bill will destroy the industry here, and that's what it's all about. It's loaded with poison pills. If we want a bill that achieves the goals that he's talked about reasonably while allowing Tennessee small businesses to have recourse against big woke companies, this will destroy the ability of Tennessee small businesses to sue pharma companies for poisoning Americans, social media companies for distorting the childhoods of our children, asset managers for putting retirement funds of hardworking Tennesseans into woke ESG mandates that lose money and don't provide for the future. That's what this is about. We're here to help. Justice is a bipartisan issue, and that's why similar measures on the federal level invoked tremendous conservative opposition because, yes, there may be a nonprofit exemption. What if you're a class of persons who was fired from their job because you didn't want to wear a COVID mask and you need a lawyer who's willing to bet it all and take a case against you? Guess what? That lawyer may need to finance that case. So again, we've done this compromise in the past. Disclosure for legitimate reasons. We want to know if the judge has a conflict of interest. Sure. Do you get the agreement with the budget in it? Well, defendants sure don't have to turn that over. No, you can't have that, but you can know who the funder is, where they're from, if there's illicit foreign money. We're fine with no illicit foreign money. That's reasonable. But when you start putting in things like joint and several liability, return caps, things that are really important for consumer litigation funding, but not commercial business-to-business funding, that's where it gets inappropriate. And that's where companies like in our trade association simply will not do business in Tennessee if this bill passes. It's as simple as that. The disclosure alone has the potential to do that, but that you add in joint and several liability. With me, we have Charles A.G. He's the leading advisor in the litigation funding space. He advises companies and law firms seeking to get litigation funding, and he'll tell you exactly why these provisions in this bill will be impossible for him to have funding deals in Tennessee. The funders simply won't do business here. And I think that's exactly what the proponents want. If that's the goal of the committee, we should pass a bill that bans litigation funding. If we want to say, like the proponent.
Thank you, sir. Hey, nice job. I'm looking for Mr. Agee. Mr. Agee, your name was called, sir. We'll put you on deck.
Thank you very much, Mr. Chairman, for the opportunity to speak. My name is Charles Agee. I'm the founder and CEO of Westfleet Advisors based here in Nashville. I'm a lifelong Tennessean, grew up in Dyersburg, Tennessee, and have been a resident of the state my whole life. And I would agree with my esteemed colleague, Daiwai, that this bill, when I read it, 95% of it actually looks reasonable, fair. It seems benign and maybe the right thing to do. But there's about 5% of the language in the bill that would, in my judgment, knowing how funders think, how they do their analysis. That's what our clients, the beneficiaries of litigation funding, companies, typically smaller companies that are in a David and Goliath situation where a larger company has committed a wrongdoing, has taken advantage of a smaller company, and without litigation funding, that smaller company wouldn't have their day in court. The types of law firms that are equipped to handle sophisticated, high stakes, commercial litigation usually don't do that on contingency fee. They're not the personal injury lawyers. So, putting caps on funders' returns, not only does it fail to recognize that these are sophisticated business entities entering into a voluntary commercial transaction, but it would just artificially distort the economics of the market. Funders have plenty of opportunities to invest their capital into small businesses and law firms in other states. And when I look at this bill, it's clear to me that this would, as Daiwai pointed out, effectively abolish the practice of commercial litigation funding in the state of Tennessee. And I don't think, as a lifelong Tennessean, that's what small businesses want for the state of Tennessee to do. Thank you very much.
Thank you, sir. Mr. Smith.
Hi, my name is Brandon Smith. I represent ILFA and some of the capital investors who are in this space, but I actually signed up to testify in my personal capacity as an attorney who launched a law firm here in Nashville. Litigation finance is not new, as you've been told. It's actually been around for over 200 years in the form of key TAM actions where you're allowed to recover on behalf of another entity, the federal government. It's also been around for the last 100 years on the defense bar side in the form of liability insurance. That essentially does two things: provides funding for defendants in litigation and allows them to shift the risk as they continue to try and manage their businesses going forward. I'm here because I don't think government should put the thumb on the scale and allow litigation financing to be available to one side of the V, but not the other side of the V. As an attorney who frequently takes on unpopular causes and clients to fight larger corporations, the David versus Goliath analogy is correct. I'm often picking up cases that would not be able to go forward without litigation financing as an option in a lot of circumstances. This bill's focus on regulation on things like disclosure and limiting foreign influence. These are all things most of everybody agrees on already. The things that we don't agree on are shifting that risk balance by imposing caps, by imposing joint and several liability, which just shifts the entire financial risk to the financiers who have no control over the case under the statute as well. The bill ultimately, in my mind, seems to look at the David versus Goliath story, but tell David he's not even allowed to pick up a few stones to throw at Goliath when he starts the fight. And I just don't think that's the appropriate way to help Tennesseans and Tennessee consumers continue to fight large corporations that are otherwise antithetical to Tennessee values and their beliefs. These cases that we're talking about are not meritless, slip and fall, sue everybody and try and get a quick payday kind of cases. They're once in a generation cases, suing large tech companies or digital platforms for the proliferation of child pornography. They're about suing organizations that have murdered and killed people in other countries and holding them accountable when they move their assets to the US. It's suing large pharmaceutical companies who misadvertise the effects of their drugs in a variety of contexts and holding them accountable. There's no lobby for this group. There's nobody else here but the folks who actually engage in the litigation and the financing, and those of us who actually pick up these clients and try and help them out. For too long, the strength of the availability of litigation financing has been solely on the defense side of the V. This bill would make sure that it was never available for the plaintiff side. Subsequently, we've tried to talk with the outside proponents that have come in from DC pushing this bill here in Tennessee. They've largely been unwilling to discuss a lot of these core issues. We've told them we agree with them on disclosure, on limiting foreign adversary involvement. These are all like very common sense things that everybody agrees to. Their red line seems to be joint several liability and the caps. We'd love to have more time to work through that. We've worked through this and had compromise bills.
Thank you, sir, for your comments. All right, so while we're out of session, do we have any questions for our guests from the members of the committee? Any questions? I see Chairman Lafferty down here. Sir, you're recognized.
Thank you, Mr. Chairman. And I'm sorry I didn't get everybody's names written down in time. The gentleman in the middle here, how is it that you're able to pick up these David versus Goliath cases without this financing process?
Mr. Smith, you're...
Sure. Well, my firm, Holtzman Vogel, and this is sort of just my personal capacity, of course, recruits clients that are somewhat unpopular all the time. Often it's just talking to friends and talking to other people we know that there's something going on. In the child digital safety space, where I spend a lot of my time these days, it's because we see the same thing in the news you do. This digital platform is allowing this terrible thing to happen. This digital platform's algorithm is addicting your kids. It's the same sort of things everybody hears about. The problem is that parents, individuals, the Ticketmaster example is an interesting one. It's things that are low financial value for individual families, but have big cumulative effects across the country. There's not an incentive for a family to spend its entire life savings to fund this litigation. The alternative is someone like me has to risk all of my life savings to fund this litigation with no support and no guarantee. Litigation financiers are essentially offering us working capital money, or almost like a loan, to be able to execute these cases in the hopes that we're successful at the end. These aren't the kind of cases where there's like a car wreck and you see a guy chasing an ambulance down for a case. These are the types of cases where the harms are serious and the financial burden is put on the plaintiffs to raise the cases. And there's just not a lot of incentive to do those cases as an attorney or as a family who has to take on that lawsuit unless
Thank you,
there is
Mr.
financial support.
Thank you, Mr. Smith. We got more questions from Chairman Lafferty?
Thank you, Chairman.
And if we could remind our guests, we're up against a hard stop here, so brevity in your responses would also be appreciated. Do we have any questions for any of the other panel members? Chairman Grills.
Thank you, Mr. Chairman. And just real quick, if you don't mind, would it not be in the interest of the investors, though, for these cases to not settle out of court or to settle quickly? Would it not be for them to recoup more money or to receive a greater return on their investment to drag these cases out further?
Who would you like to see that directed to?
Whoever wants to answer it.
All right, well, let's go back with is Daiwai?
Daiwa, yes,
Yeah.
we would prefer settlement. Defendants obviously are not willing to settle in these cases oftentimes until they've gone to trial. But in any event, the fee cap doesn't work. It'll just raise the price for Tennesseans. If you price a case for litigation funding, typically it's a multiple of invested capital or an interest rate. So a litigation funder will say, I'll invest in your case. If you win $100 million and I've invested $2, I'm going to get 2 to 3 times my money back, right? It's calculated like that, and the plaintiff will get whatever is left. If you cap it, say, at the same amount as the plaintiff, now litigation funders will all price it and say, well, we're going to get 50% of what you get in perpetuity because we need to protect against a downside scenario where this case didn't go well. So the rate cap actually has the perverse incentive. And then 10%, by the way, Mr. Agee could speak about it, but if you wanted to have a rate cap that would actually allow the market to proceed, you'd need something much higher. These are typically priced well in excess of 20%, 30%, because they're so risky and there's complete risk of loss for litigation funders.
Chairman Grills.
Would he have a response?
I do. So the 10% number that we're hearing is a fee cap. It's not about the return on investment. That's to make sure that they don't shift the saying that you can't get more return on your investment than the plaintiff in the case actually gets, but you can't hide that money and shift it and just charge it in fees. And so that's all the 10% cap does is it caps the fees, not the return on investment.
Thank you, Mr. Chairman.
Chairman Grills. All righty. I see no other hands. I don't have anyone else on the list. So, gentlemen, thank you for joining us today. We appreciate your views, appreciate you sharing them, being so articulate about them. Obviously, a lot of passion on both sides of the aisle on this one. So anyway, thank you very much. And we're going to go back in session. Chairman Boyd, you're recognized.
Thank you, Mr. Chairman, and I appreciate everybody coming to talk. And hey, those guys were good. I mean, that was pretty clever to come in here to a Republican committee and throw out those terms like DEI and all of these different things that we've dealt with. But at the end of the day, this does not outlaw litigation financing, and this only applies to commercial. And it just puts some guardrails in place. As the guy just mentioned, the financier cannot benefit more than the plaintiff. This simply puts the plaintiff at the center of the lawsuit and makes sure that their needs are prioritized over the investor. And it prevents them from shifting. I know some people are hung up on the 10%. It prevents them from shifting that cost over there in order to double dip on it, essentially. And it protects against foreign adversaries from being involved in this. So at the end of the day, this is not they use the David and Goliath analogy. This would be telling David what he has to do and making him go out there and use a different weapon system than the slingshot and telling them. And in this case, it would oftentimes the plaintiff is ready to settle. They're done. Their needs are met. They've got what they want out of it. And then the financier is dictating to them how the lawsuit goes after that. And so this puts an end to that, and it just simply puts some guardrails in place. This industry is not going to be outlawed. I can assure you that investors will find a way to continue doing this. But this is necessary in the commercial litigation financing arena. And I would ask that this committee pass this bill on. Thank you, Mr. Chairman.
Thank you, sir. Any final questions for our sponsor? I see no hands up. So with that, unless I hear objection, we're going to call for a vote on this. All those I'll tell you what, Madam Clerk, how about lighting that board up for us? There you go. And all those in favor, vote yes. All opposed, vote no. Anybody want to change their vote? Anybody want to vote? Okay, so we've got enough votes up there. Madam Clerk, if you would read the totals.
Mr. Chair, you have 16 ayes and no nays.
All righty, thank you, ma'am. Folks, we are up against a hard stop. We've got to get the insurance committee in here. Excuse me, Chairman Boyd has requested a quick 2-minute bill, but we'll be the determiners of whether or not we can do it in 2 minutes. Chairman Boyd, you're recognized on House Bill 1916.
Thank you, Mr. Chairman. I do have an amendment, Mr. Chairman. Drafting code 014357.
We got a motion and a second. All those in favor of attaching Amendment 1014357, please signify by saying aye. Any opposed? Noes? Amendments attached. You're in proper posture, sir. Let's roll.
Thank you, Mr. Chairman. This simply reduces the continuing education and classroom licensing for real estate professionals that also do short-term rentals. The amendment, we had some lawmakers from the Smoky Mountain area that were concerned with some of their short-term rental managers up there. So it just simply clarifies that it does not put them under a broker. They can continue to operate as they did before, Mr. Chairman.
All righty. I don't see any questions, so we will call for the vote unless there's objections. Please light up the board. Madam Clerk?
All I need is 30 seconds.
Madam Clerk, please call the vote.
Mr. Chair, you have 14 ayes and no nays.
All righty. House Bill 1916 is off to finance. And with that, ladies and gentlemen, do I hear a motion to adjourn? I hear a motion to adjourn. We will see you back, same bat time, same bat channel next week. We are adjourned.